There is only one president in U.S. history who was also Chief Justice of the Supreme Court, William Howard Taft. And of the two jobs, Chief Justice was the one he really wanted. I'm Bob Summers, and this is a presidential story. William Howard Taft never really wanted to be president. Taft was the son and grandson of judges, so it was no surprise when in 1892 Taft's career path led him to the position of federal appeals court judge. In a speech, Taft once declared, "I love judges and I love courts. They are my ideals that typify on earth what we shall meet hereafter in heaven under a just God." His work on the bench was noticed by those in politics. President William McKinley named Taft to become the first civilian U.S. governor of the Philippines in 1901. This would be the beginning of his road into politics. In 1902, President Theodore Roosevelt informed Taft that he wanted to put him on the Supreme Court. Taft confided to then Secretary of War Elihu Root, "I long for a judicial career, but if it must turn on my present decision, then I am willing to lose it." Taft's sense of duty to finish his work in the Philippines, combined with his wife Helen's urging that Taft's political career not be stalled in the Supreme Court, ultimately won out. In 1904, Taft once again followed in his father's footsteps when President Roosevelt appointed him as Secretary of War. Taft's father, Alfonso, was Secretary of War under President Grant. Now living in Washington, D.C., Roosevelt again tried to persuade his friend to join the Supreme Court. Taft wrote in his diary that Helen was bitterly opposed to my accepting the court position and that she telephoned me this morning to tell me that if I did, I would make the biggest mistake of my life. Taft once again declined the nomination. After a private half-hour meeting with Helen Taft, President Roosevelt became the most vocal proponent of Taft's bid for the presidency, and he never mentioned the Supreme Court to Taft again. When Roosevelt decided he would not run for a third term, he endorsed Taft as his heir apparent. And he won. During his one term, Taft appointed 6 Supreme Court justices. Only George Washington and Franklin Roosevelt appointed more. One of those appointments was a promotion for Associate Justice Edward Douglas White to Chief Justice. This was the first time that an Associate Justice was promoted to Chief Justice. Earlier, Taft had promised the Chief Justice promotion to Charles Evans Hughes if an opening became available, but he reconsidered. Maybe he thought Hughes might outlive him, which he did, thus denying Taft his own opportunity years later. When he promoted Justice White, Taft confided to his Attorney General, George W. Wickersham, that "there is nothing I would have loved more than to be Chief Justice of the United States. I cannot help seeing the irony, in fact, that I, who desired that office so much, should now be signing the commission of another man." Former President Roosevelt was not happy with Taft's job performance and decided to run against him in 1912, thus splitting the votes and ensuring that Democrat Woodrow Wilson would win the White House. Taft came in a distant third, only winning 8 electoral votes. Taft didn't seem too concerned. Happy to be relieved of the burdens of the presidency, Taft returned to what he loved, the law. For the next 8 years, Taft was a professor of constitutional law at Yale. He even spent time assisting President Wilson with his failed campaign to convince the United States to join the League of Nations. During the 1920 presidential campaign, Taft supported the Republican ticket of Warren G. Harding and Calvin Coolidge. Taft and Harding had history. Both were from Ohio, and Harding was the one who officially submitted Taft's nomination for president at the 1912 Republican National Convention. So when Harding won, he asked his friend and former president to visit him at his home in Marion, Ohio, to advise him on appointments. It took a while for their schedules to align, so they did not meet until Christmas Eve. As Taft would later recount, after speaking for about an hour on Harding's cabinet choices, Harding casually asked Taft if he would accept an appointment to the Supreme Court if a seat opened up. If so, Harding would appoint him. Since this was something that Taft had wanted for so long, one would think that Taft would be prepared for the question, but he was not. He stumbled through his answers so badly that he was compelled to write a letter to Harding the next day, Christmas Day, to explain himself more fully. The letter included the reasoning for his one condition, that he would only accept the position of Chief Justice. I was so much startled by the personal question you asked me that I am afraid that my answer was confused and seemed presumptuous and unappreciative. Ever since I came to the bar, I have aspired to the Supreme Court as my life's goal. Twice I was obliged to decline the opportunity for reasons I explained. Then I was young and would have been glad to take an associate justiceship and work up from the junior membership toward the head and perhaps to the chief justiceship if fortune favored. But now I am 63 and could not expect to serve more than 10 years. I have been president. I signed the commissions of 6 members of the court, and 3 are still on the court. I joined 4 presidents of the American Bar Association in petitioning the Senate to reject the nomination of Brandeis as not a fit one to be made, and have not changed my mind. And I would feel ill at ease to come into the court after having been president as the junior of my appointees, and of the man I tried to defeat. Were I Chief Justice, I would hope, by reason of having been president, to have some little more influence in securing a greater solidarity of opinion among the judges, so necessary to maintain the court's influence with the public. It was for this reason that I ventured to say that I could only accept the Chief Justice's position. The present Chief Justice, when I have seen him in the years past, has said to me that he was holding on for me and to return the place to a Republican administration. I can't say that he still feels this way, though I know he greatly rejoiced at your election. Even if you conclude that someone else ought to be Chief Justice as well you may, I hope you will believe me when I say that I am deeply grateful for what you said to me yesterday, and that it was one of the greatest honors of my life, and makes this Christmas for me the brightest and happiest of my life. Harding sent a response a few days later thanking Taft for his advice, but made no direct mention of the Supreme Court. It was not until January 1921 that Taft heard through intermediaries that Harding planned to appoint him, if given the chance. Chief Justice White, who had been appointed by Taft, was in failing health when Harding was sworn in. On March 4th, 1921, Taft visited the Chief Justice on March 26th, finding White ill, but still carrying on with his work. There was no discussion of retiring. Less than 2 months later, on May 19, 1921, Chief Justice White died while still in office. Taft issued a tribute to the man he had appointed, and then waited to see if he would be named the next Chief Justice. And waited. And waited. Harding did not make a quick decision. While Taft was lobbying Harding's inner circle, he was unaware that Harding had also made a promise to former Utah Senator George Sutherland that he would also be named to the bench. Harding was waiting because he was hoping that another spot would also become vacant. Finally, Attorney General Harry Doherty, a supporter of Taft's candidacy, urged Harding to make a decision. After 42 days, on June 30th, 1921, Harding named Taft Chief Justice. Immediately after hearing of his nomination, Taft sent a telegram to Harding. Have just heard that you have nominated me to be Chief Justice of the United States. I am deeply grateful for your confidence that I can discharge satisfactorily the duties of that exalted office and hope that it is not misplaced. The Senate confirmed Taft on the same day, 61-4, without any committee hearings and after a brief debate in executive session. Taft was sworn in as the nation's 10th Chief Justice on July 11th. Speaking of swearing-in ceremonies, as Chief Justice, Taft had the unique honor of being the only president to swear in another president when he administered the oath of office to Calvin Coolidge at his second inauguration in 1925 and to Herbert Hoover in 1929. While Chief Justice, Taft kept the promise he wrote to Harding in his Christmas Day letter to secure a greater solidarity of opinion among the judges. During Taft's tenure, 84% of the Taft Court's opinions were unanimous. Taft said, most dissents are a form of egotism. They don't do any good and only weaken the prestige of the court. Taft personally wrote 253 opinions, or about 1/6 of all decisions issued during his term. He only dissented 20 times, and of those, he only wrote 4 of them. The Taft Court's rulings were generally conservative and limited the role of the federal government and unions. Many have not stood the test of time, or, as Supreme Court Justice Antonin Scalia put it, many of them ran counter to the ultimate sweep of history. In Gong Lum v. Rice, the court upheld school segregation by ruling a child who is born of Chinese heritage could be classed by the state to attend public schools segregated for non-whites. In Bailey v. Drexel Furniture Company, the court ruled that a tax that Congress passed on the sale of items made with child labor was indeed not a tax, but a penalty, and was thus invalid. They ruled that child labor is a problem for states to solve. This decision was overturned in 1941. In Atkins v. Children's Hospital, the court again ruled against Congress when they tried to guarantee minimum wages for women and children working in the District of Columbia. This was one of Taft's written dissents. In Olmstead v. United States, as part of the enforcement of Prohibition, the court ruled that warrantless wiretaps of phone conversations could be used against defendants in court. This was overturned in 1967. Also, as part of the Prohibition enforcement, the court ruled in Carroll v. United States that vehicles can be searched without a warrant because the vehicles could be easily moved to another jurisdiction before a warrant was obtained. These decisions and many others were overturned after Taft passed away, but some rulings still remain valid today. In Federal Baseball Club v. National League, Taft's love of baseball intersected with his love of law when the court ruled that professional baseball is not subject to the Sherman Antitrust Act, which restricts anti-competitive actions by businesses. This exemption still persists today, allowing Major League Baseball to take steps to thwart competitors that other sports leagues cannot. The decision Taft most valued was in Myers v. United States. The court's decision invalidated tenure of office acts which limited the power of the president to remove subordinates who had been approved by the Senate, in this case, postmasters. President Andrew Johnson's violation of a similar law led to his impeachment by the House of Representatives. While exceptions have been established over time, the general principle of Myers has been reaffirmed as recently as 2020. As spotty as the judicial record of the Taft Court is, where Taft made his mark on the Supreme Court was in his administrative and operational processes. At the time Taft became Chief Justice, the federal appeals process could take up to 5 years. There was a huge backlog because the workload of the lower court judges were not balanced, and there were not enough judges. Taft worked with Attorney General Dougherty to draft legislation requesting 24 more judges, and the ability for the Chief Justice, who Taft believed should be responsible for the federal courts, to move judges around to where they were needed, in coordination with a panel of senior circuit court judges. The bill passed in September 1922. Another reason for the backlog at the Supreme Court was the large number of cases that could be brought before the court. At the time, anyone could appeal to the Supreme Court, and the court would hear their case. Taft and the other justices drafted their own legislation to limit the types of cases that had an automatic right of appeal. This allowed the Supreme Court to only accept cases with major constitutional questions, while declining to hear those that could be sent back to lower courts. With unprecedented lobbying and testimony from a Chief Justice, the so-called Judges' Bill was passed in 1925. Within a year, Taft was able to report that the backlog was shrinking. In another lasting impact on the Supreme Court, Taft pushed for a standalone building for the Supreme Court. From 1860, the Supreme Court met in the cluttered, crowded, overheated offices in the basement of the Capitol building called the Old Senate Chamber. The conditions were so terrible that most justices insisted on working from home. Taft's vision was for a building that would highlight the court's independence and equal status amongst the 3 branches of government. In 1929, Congress approved $9.7 million for construction of the court's permanent home. The cost was not meant to include furnishings, but it came in under budget, even with the furnishings. Almost $100,000 was returned to the Treasury. Unfortunately, Taft did not live long enough to see the building completed in 1935. Despite his own failing health, Taft insisted on traveling to Cincinnati, Ohio, to attend the funeral of his brother Charles, who died on December 31, 1929. When the court reconvened on January 6, 1930, Taft was not present. He needed rest, so he traveled to Asheville, North Carolina by the end of January. but soon was hallucinating and having trouble speaking. Taft knew his time was running short, but wanted to secure his legacy. He told President Hoover that he would not resign until he was assured that former Associate Justice Charles Evans Hughes would become the next Chief Justice, keeping his promise to Hughes some 20 years later. With Hoover's assurance, Taft resigned as Chief Justice on February 3, 1930. Less than 5 weeks later, on March 8th, Taft passed away at the age of 72. Taft became the first president and the first member of the Supreme Court to be buried at Arlington National Cemetery. His funeral was the first presidential funeral broadcast on radio. Thanks for watching.